A great day so far, and everyone is getting back to normal schedule here in Texas with the crazy last week we've had. As Scott mentioned, I am Lee Leppert. I'm the Senior Creative Manager here at the Cromeens Law Firm. And today we have Miss Karalynn Cromeens. She's the owner and managing partner of the Cromeens Law Firm. And she'll be presenting everything you need to know about the AIA A201 contract. She'll be breaking out different sections, explaining what they mean in plain English, which is very important to understand, and discussing dangerous provisions and what the contract terms you need to be on the lookout for. And this information is absolutely crucial to you and the success of your business, and we hope you find everything informative. And we will have a Q&A at the end of the presentation. So if you raise your hand or if you want to send a note in the chat, I will call on you, and you can also unmute yourself and ask Karalynn any and all questions you may have for her. This is the perfect time for you to get all your questions answered. And we hope that you take advantage of that time. There was a handout that was sent out, so you can follow along and fill in the blanks as we go through the presentation. All right, and I think we are recording, so I'm going to start this right here. All right, Karalynn, if you want to go ahead and take it away.
What is the A201? Basically, it's a set of instructions on how the owner, contractor, and architect should work together. It's a very lengthy document, and so what I've done is I've read through the whole thing. It's not an unfair document at all. I've read, plenty of subcontracts and general contracts. It's pretty fair. But what I've done is I've gone through the major areas that are important in the construction project and how all three parties work together. The changes in work, the payment how payments are made, how all that's done. Termination we'll go over, and we'll go over claims and disputes. And then if you have any questions about any other parts, I've read the whole thing. I've been through it all. I just kind of prioritize our time on what issues we can have. So the first thing I want you to notice is that there are no signatures on this document. What does that mean? Why is that important? That means that this document is incorporated into another document. For the owner and the contractor will be the general contract agreement. There'll be a section on the front that says contract documents, and it will incorporate this agreement. The same with the agreement between the owner and architect. It will incorporate this same agreement. So why is that important? Before you sign that contract, you want to make sure you get a copy of these to make sure they're not changed, or that if you want to make any changes, you can do that before you sign that. Because once you sign that overarching contract, whether you've seen this or not, you're now responsible to work by it. So knowing what this says, making sure that there are no changes that have been made, or making sure the changes that you want to be made before you sign the main contract is essential. Because after you sign the main contract, there's really no negotiation. You signed up for whatever terms these are, regardless if you've seen them or gotten a copy. So with that, we'll dive right in to changes in work, which is under Article 7. There are 3 ways under this contract to change work. All right, the first one is a change order. And so the change order has got to be agreed to by all 3 parties. How it works logistically is the architect drafts it, the owner signs it, and then they produce it to the general contractor, who signs off on it as well. It must include any change in the work, any amount of increase or decrease, and a time adjustment if one is required. As with any contract, if you're doing any work that's outside of the scope that you were hired to do, make sure you get a written change order before you do the work, or you will not be paid for that extra work. So that's the first way. When everybody agrees on the work that's to be done, the price that's to be paid, they can sign off on it, and this change order now becomes part of the contract documents and increases the contract price. Okay, construction change directives, or what I like to call a cram down. Basically, what happens in this is that the owner, this is where the contractor or all 3 parties can agree to the increase or decrease in price. So the owner and the architect and the owner get together and say, this is the change that needs to be made. Here's what here's the price that we're willing to pay. And the contractor, whether he agrees or not with that price, needs to move forward with the work. He needs to make sure he's made it clear he's not in agreement with that price. So regardless, he says, okay, I'm not in agreement with the price, but the project has got to move forward so that it needs to keep moving. So the contractor is required to keep moving forward, regardless if you agree on the price or not. Some of the ways that it can be resolved is if there's a lump sum amount that everybody agrees to at the end of it. If there's a unit price that is already in the contract for this particular increase in price, or if the general contract already calls for, any changes will be cost plus 10%, then it'll already be resolved beforehand. And so once the price on a directive is agreed to, then it just becomes a regular change order and all three parties agree to it, and it goes on, it gets increased. The main thing is that if you're moving forward on a construction directive, as a contractor, keep copies of all the receipts and everything, even employment, extra time records, every cost related to this increased price. And so what happens as a matter of course is that once you've done the extra work, and you still don't agree on the price, you'll submit all of your, proof of expenses to the architect. The architect will review them, take into account your overhead and things like that, and issue what they think the fair price for the change should be. If the contractor doesn't object promptly, and I don't know what promptly is, so I wouldn't wait very long. If you object, I would do it within a couple days. Then that is the price that the contractor will have paid for the increase of price. Same goes with the increase in time. The time and the money are going the same way. If the contractor still objects and doesn't think it's enough, or it's too much, if it's a deduct, then you have to follow the provisions under Chapter 15, which are for claims and disputes, which we'll cover later on. So the main thing to know about the directive is that even if contractor doesn't agree with their price, they have to move forward. Save all the documents that are required to increase or decrease whatever you have proof of, so that way you can submit it to the architect at the end of it and see if you can agree or not. So that is how the directive works. And so at that point, if everybody agrees, it becomes a change order. If not, it goes through the claims and dispute in section 15, which we will get to. There's also in the handout the page from the A201, which is the directives. All right, minor changes in work, which are changes which in the architect's opinion should not increase the contractor's time or price. So what happens is the architect and owner issue the contractor a minor change in work change order, which says do XYZ or remove XYZ. If the contractor agrees that that there's no increase in price or time, then they move forward with the minor change in work. If the contractor disagrees, the main key is don't move forward with the work, and give back a written notice of why you think you would be entitled to an increase in price or an increase in time. If you move forward without objecting, you waive your right to that extra time. So consider, once if you get a minor change in work issued at it, look at it, what it really is, and make sure that before you move forward with the work, that it's not going to cost an increase in time or money. And that's also under Article 7.4 in the actual document. The main thing with any of this, the request for extra work or all of that, make sure you have great written documents, emails, daily reports, something that's showing what's going on in the written version at the time it's going on. If a dispute does arise, that is, important stuff to have later on that your attorney would love to have. He told me to do this, or she told me to do this, and then they would pay me, wouldn't be enforceable if you have a written contract. One of the next big articles I think is important is time. The time to complete the project will generally be referenced in the main contract document. So like the general contract will have the schedule, and the schedule attached is what you need to complete the project on. And make sure it's something reasonable, because the schedule that you agree to is what delay/liquidated damages is based on. So make sure before you sign the main contract that the schedule attached is something you can agree to. It's a contractor's job to keep the project moving. If the contractor thinks there's something that happened on the project that wasn't their fault, that they should be entitled to more time, that request needs to be made in writing to the architect. And then the architect will decide if yes, you are entitled to more time and here's how much. If no, then the architect will decide that. After the architect's decision, if the contractor still doesn't agree with that decision, then they need to write a written objection and then follow the procedures in chapter for claims and disputes, which the time stuff is all in Article 8. Another very important part is payment and how payment works between the three parties. So every month, it depends on the timing of the pay application, depends on the main contract. You'll submit a pay application for that time frame, normally a month of work, and any materials that have been delivered, even if they haven't been used on the project site. Okay, so the contractor submits that pay application to the architect. Once the architect receives that pay application, they have 7 days to respond. I can't tell if you need to go to the next slide or not. You might. Okay, and so basically, yes, once the architect will respond within 7 days with one of the three following things. Issue a certificate in payment of the full amount of the pay app, which means there's nothing wrong, everything's ready to go. Issue a certificate of payment of something less, and then a reason why it's something less than the full amount, or withhold the entire amount of the pay app and let the contractor and owner know why the entire amount is being withheld. There it does say in the document itself that once the payment is certified, that is, it is presumed that the work is done in accordance with all the plans and specifications. That is it. Like if you come to me with a dispute later on about your work and you have a paid pay app, and I know that this presumption is in your contract, that's huge. If a dispute ever arises, be like, look, we already paid for the work according to your own contract. It was in accordance with the the contract documents. If it comes along later that something that glaringly was not, it probably won't work. But if there's some if it's a close call, this is a great way to button that up and say, hey, I did exactly what you told me to do. You even paid me for it. So that's a good thing to know if you ever get into dispute that it's there. Okay. Next slide, which is the reasons why the certification can be withheld. The work is not, that there's a defect in the work that's not corrected is the reason number one. The architect can withhold certification. Any claims that are.
I just wanted, because Brad will ask me probably if I saw it.
Oh.
Yeah.
So
Yeah.
how long is she talk?
Pardon?
How long does she talk?
Sorry.
I don't know. I would imagine best part of an hour.
You think?
I would think. I don't know.
30 minutes? If it's at a lunch.
Mhm.
Okay, so
Oh no, she has a spelling.
Spelling error.
okay. So a third reason that the certification be withheld is for non-payment for subs or suppliers. Another reason is that if the contractor cannot reasonably, if in the architect's opinion, the contractor cannot reasonably finish the project for the remaining contract price. Damage to another owner or separate contractor, or reasonable evidence that the contractor won't finish the project on time and there's not enough money left to cover the delay damages. These are all reasons why the architect can withhold certification of payment. Okay, and then if payment's not certified due to non-payments to sub or material suppliers, the owner can pay them via joint check and then let the architect know. If there's a dispute, if like say the pay app is partially certified, the owner should pay that certified part, and then you can either resubmit on the next pay app for the difference or go through the dispute process if you disagree with the partial certification as a contractor. Okay, so if the architect doesn't issue a certificate of payment within 7 days or any kind of reason why not, the contractor can then give us another 7-day notice that says, hey, if I don't receive whether this payment is being certified or why it's not within 7 days, I'm going to stop working. And then after that, they can stop working if the payment hasn't been certified or reasons why it hasn't been certified isn't given. Some other things that I thought were interesting is that an owner can request lien waivers from subs and suppliers. And if the contractor doesn't provide them with 7 days, the owner can contact the subs and suppliers directly to get those. Another interesting thing is that if sub calls the architect or owner and asks if their scope of work has been paid, that information can be revealed. So those are all things that are legal under this agreement. All right, next very important section, termination. All right, there are 2 ways to terminate on this under this contract, for cause and for convenience, and we'll get to convenience in a second. But if you were going to be any of the following reasons, you can be terminated for cause: a court order, an act of government, the owner has not paid on time. This is when the owner can the contractor can stop the work. Sorry, I was going backwards. This is when the contractor can stop work. Court order and act of government, if the architect has not issued a certificate of payment, the owner has not paid on time, which is a great thing to keep the owner responsible for paying you on time. And another thing that I thought that was interesting that I've never seen before is that the contractor can ask the owner to prove that they financially can afford to pay them to finish the project. That's under section 2.2. If the owner fails to do that to the contractor's satisfaction, they can stop working. The contractor, they can send the owner notice of default if it's not cured within 7 days. They have the right to terminate. Okay, the next section is when the owner can terminate the contractor for cause. Did not man the job properly, fails to make payments to the subs or material suppliers, does not follow the law, or any other breach of the contract. So any of those reasons, they can, and what it is, they give you notice. You have, I think, 7 days to cure. If you don't cure the defect, then you can be terminated. All right, so what is a termination for convenience? Termination for convenience, this means you can be fired for any or no reason at all. When this normally plays out, what I see, and only the owner has this right to terminate the contractor. The contractor does not have the right to terminate for convenience. This normally plays out, I see this when the contractor signed the contract, they're getting ready to start the project, and the owner finds someone to do it for cheaper. And they can terminate it and hire the new contractor for a lesser price than what they hired the first contractor for. Or it's also used if they didn't follow properly the termination for cause. Say they didn't give you the required 7 days notice, they did it improperly, or you fixed whatever the default was, then they'll be like, it doesn't matter, I terminated you for convenience. So that's something to be leery about. I try to make it mutual as you can, at the very least. I think that's one of the terms I would try to negotiate. All right, claims and disputes. So there is a process for the claims and disputes that are in chapter 15. And basically the architect is the decision maker, and he gets to make the first decision on everything. If you disagree with the architect's decision, you can give a written notice of your objection. And then the next step would be to go to mediation. Have all the parties go to mediation, where sit in front of a third party who's agreed upon the parties, and see if you can't settle it that way. And if you still can't settle it that way, then the contract does call for arbitration, which is through the AAA, which means not courtroom litigation. You would have not a judge, you would have an arbitrator that's chosen by the parties decide the dispute. So it does call for all that. I mean, I think in the current situation, arbitration is actually preferred, just because you can get a dispute decided way faster than you could in a courtroom. Right now, with COVID and everything that's going on, jury trials are way backed up, and so are regular trials for that matter. So in arbitration, you can get to, a decisive hearing within, depending on the amount of dispute, 90, 120 days. Bigger disputes would obviously take longer, but as opposed to 2 to 3 years that you're now waiting in the courtroom to try to get any final decisions. So I think that is probably going to be the wave of the future, hopefully, because you can get things decided and parties can move on and not have to pay lawyers so much money. Okay, so some just FYI that I thought was interesting. First, you need to know that just a general rule in every contract is that whatever you bid does not become part of the contract. And why does that matter? Because everybody thinks they're hired to do their bid. They're not. They're hired to do their scope, which the scope is attached to the contract, which could be different and normally is at least a very little bit different, at least a little bit different than your bid. So when you get the contract that's got the scope attached, review it as if you were bidding a new project and make sure it matches up. You don't want to miss something and then you're like, oh, well, I didn't bid that. But like, yeah, it doesn't matter. Our agreement's a scope. So another thing to watch out for in section 121 is reasonably inferred. What this says is, even if I miss something in the contract documents or the plans of specs, if it can be reasonably inferred, then you're required to do it. It doesn't say who gets to decide what's reasonably inferred or the ramifications of that. It's entirely too broad and is a very dangerous provision. So if there's anything you would change, I would try to change that provision, take it out entirely. If we have a written agreement, there shouldn't be anything reasonably inferred. If it's not in the agreement, then there would be a change order for the increased price. So reasonably inferred shouldn't be that included. Evidence of owner financial arrangements, which is 2.2, I already kind of mentioned. If the contractor thinks the owner is not financially fit to pay them for the finishing the project, they can ask for reassurances. Contractor needs to visit the site. 321, the section in the contract that says that you visit the site, you're aware of everything out there at the site. And why does this matter? Because if there's something out there that could potentially increase your contract price, you're not going to be entitled to a change order for it. Whether it's parking, where is there storage for? Is there storage place to keep materials, dumpsters, all of that? You need to visit the project site, because whatever you don't see and increase your project price you won't be entitled to a change order for it. Another thing that I found interesting is the incorporation of the prime into the subcontract, which generally happens. Most subcontracts incorporate the prime, which means the subcontractor is responsible to not only follow his subcontract, but follow the terms of the contract between the owner and the general, which most subcontractors don't even realize is in there. So, but according to this, if that happens, then the subcontractor gets the benefits of the same benefits of the contract. What that means is that if the contractor doesn't pay the subcontractor and the owner hasn't paid the contractor, now the subcontractor could sue the owner directly in a breach of contract, which I know sounds convoluted, but that's never allowed under contract rules. Usually the only way a subcontractor has a claim against the owner is through lien rights. So this actual documents gives the subcontractor the benefits of the prime contract, not just the obligations, which it was great to see, because that's one of the ways when I'm representing a subcontractor, negotiating a subcontract, says if you want me to be, I say if you want me to be responsible for the prime, then I should get some of the benefits as well. So the fact that that's built in is good to see. So I kind of went over the highlights of this, and I'm open to any questions on anything in the agreement because I've been through it all. So if you have anything that you need to know about specifically or generally how it works, I can answer it for you because I have it here. So Lee, I don't know if we have anything in the chat roll or not.
Thank you, Karalynn. Yes, I'm checking right now. Let's see. right. Let's see. Scott, is there a way to send Rick the, I hope everyone received the handout, and we can, we'll definitely send that out so everyone can go through the presentation. We'll be sending a follow-up email with the full presentation so you guys can follow through and fill out the handout as well. The handout is a little bit more dense, so it has a little bit more information for you to take home. Thank you, Robin. Everyone's thanking you for presenting. Looks like Linda has a question. Let's see. There are times the architect signs the contract before the contractor is on board. So the architect needs to review the owner contractor contract before the owner signs. What if they don't agree with the architect comments?
Because the owner and architect agree first and the owner and contractor agree later. So the architect would have to see this before they sign as well. And then they could make any changes that they want. And then when the contractor signed, they would need to see the version that the contractor and architect already agreed to. And then they can see if they would agree to any of those changes or make any additional changes before they sign the main contract, because this would be incorporated that way.
Perfect,
I think I answered that
you.
question. If not, let me know.
Okay, looks like everyone's asking for the handout. That's great. We'll definitely get you the handout in full presentation, so everyone will have that to take home after we present. And feel free, if you would like to raise your hand, there's a way to do that on the Zoom call. You can raise your hand and unmute yourself and ask Karalynn directly any questions you may have. And again, any questions you may have, you can also submit in the chat and I'll read it out directly to Karalynn.
Hello.
Hi, Peter.
Hi. There's a couple of things. I've been looking at this document as it evolved since 1976, I think even before. And so I'm glad that you find it reasonably fair, because it has, I know the people that actually draft this and they try to do that. There's a couple of things. One of them, in terms of the changes in contracts, it's important to understand, I think, that there is a design contract between the owner and the architect, and then the construction contract that you're generally talking about here. The provisions of AIA A201, the definitions in some of the provisions bleed through to the design contract, okay? But they are two separate contracts. Sometimes what I see is that the contractor and an owner make changes or agree to a contract that that changes the design contract. And I remember on several occasions where the construction contract requires the architect to have full-time on-site clerk of the works kind of services, which is almost never done except on the largest of contracts. So, you know, I used to have a lot of heartburn over it for the last 20 years. I've told my clients, architects, don't worry about that. You don't have to do any of that crap because you didn't sign that contract. Okay. And so, you know, if the contractor says, well, the architect has to do such and such, architect doesn't have to do jack if he didn't agree to it. Okay.
Yeah, and what you would see is in his agreement with the owner, either he incorporates this document or not. If the document's not incorporated,
what document?
The A201.
Yeah, it always is. It has to be.
But if it's incorporated, then I don't. So because it
they
does
make changes. They make changes, you know, that place additional obligations on the architects. And when I used to work in an architect's office, I would see those and alert my boss to those. Mm-hmm. I don't see those as an independent consultant so often anymore. Yeah. The other thing I'd like to point out is that in the AIA A201, they don't really talk about defective work. They talk about non-conforming work. And there's a really important difference. The work may not be defective and still be non-conforming. And if it doesn't conform to the contract requirements, then the contractor's obligated to make it conform. And I will see, usually on smaller projects, but sometimes on larger projects, contractors try to improve certain details or certain work, and then say that it's you know, this is the original detail was defective or whatever. If he changes it, he's bought it, especially if he didn't get approval from the architect.
Well, and that's the thing, is to get the pre-approval. If not,
Yeah,
because
but you'd be surprised at how often that doesn't happen.
I'm
And
sure.
the most common way that it doesn't happen is that there will be a submittal, usually a shop drawing, that makes his changes in the work that the architect goes ahead and approves. And that's not the way that changes in the work happen. And the contractor can't come back and say, oh, you approved the shop drawing change, so I want more money.
No, I agree. I
But-
agree, but I have a question. It could lead to, even though it's not, it could make it conforming work though. He can't get a change order that way.
Okay, the submittal, shop drawing, action on a shop drawing does not change the contract documents, except in stupid people's minds.
I agree with the change order provision. I don't know about, I understand that it says in here, even if it doesn't comply, then it's not an effective change. I don't know how that would play out legally if it was approved.
Well, I have heard of a subcontractor who didn't get paid for work because the architect made a change on the shop drawings, and he went ahead and defected that change, and the general contractor said, what you delivered to the job site doesn't comply with the contract documents, so I'm not going to pay you.
And that could be for a multitude of reasons, because subcontractors want to fight with the general contractor, or the the fees to do that. The main thing that if people are reasonable, you can't affect a change order in a submittal, but there would be, depending on the arbitrator or who you got to decide it, there would at least be some reasonable fact questions that, as long as it wasn't defective, it was defective, all bets are off. You know what I'm saying? So I don't know, the contract definitely says that it shouldn't be allowed that way, but approved submittal, I'm not sure.
It gets real tricky on minor changes in the work where you issue an architect supplemental instruction, okay? And then a lot of times what that will result in is come back with a change order request on the part of the contractor. It says, okay, this isn't a minor change in the work. The other thing that can happen is the contractor issues an RFI, architect says, well, you need to do it this way, and then that results in a request for a change order as well. But I agree with you if everybody's reasonable, but good contracts are like fences. They make good neighbors. And I see a lot of architects and contractors get into problems because they don't follow the rules. And a lot of times because they don't draft proper specifications to begin with. It's not so much the drawings that get them in, well, I shouldn't say that.
But you brought up initially that I think the architect has some duty to go out and inspect throughout the project. The question arises is that because it's in this agreement that technically both the contractor and architect and owner to abide by, could the contractor have a claim against the architect for failing to do what's required in the A201?
Well, the observation is not supervision. And there's a long history of trying to clarifying that, going back, I think, to the 76 edition. Very few owners want to pay the architect to be on the site that much. And most of the time the architect doesn't have enough money to do it. And so a lot of times what will happen is the contractor will screw up and say, well, the architect didn't fix this. And the other thing is when you're on the job site, it's the contractor's job site. his obligation to supervise the work. And the architect, when they go on the job site, ain't supposed to talk to anybody except for like the superintendent.
I agree.
Okay. The exceptions are if you see somebody working in a 7-foot deep hole that's about to cave in, you can sort of jump in and say, get the hell out of there without getting into trouble. But otherwise, you ain't supposed to say anything on the job site. So the architect's responsibility for the level of supervision that you're talking about is very small. If he crosses the, and you know, I've been Falling Water in Bear Run is a really good example where Frank Lloyd Wright was on the site redesigning the building almost constantly all during construction.
Mm-hmm.
We just don't do buildings that way anymore. A lot of architects would like to, but we just don't, and we can't.
Well,
Okay?
I'm sure the expense involved would be huge.
Exactly.
You know, to try to.
And the contractor would like to get out of that liability, but in fact, they have some liability for executing the contract for construction in conformance with contract documents and in conformance with the level of expertise consistent with their position in the contract industry.
Well, I agree, which I think is why it's essential that all parties know what's required, and then it's so much easier
Exactly.
if he knows what the ramifications are, how things are to work, then they can all work together, you know, to get everything done in a much more efficient way. And the same goes for the subcontractors too. They need to understand what they're agreeing to and signing up for.
You'd think.
I'm on a mission, man. I'm trying to educate. You know, the AIA is a great document because it's standard. Because the stuff that's out there right now, as far as subcontracts and even some general contracts, there's just, I mean, you can't believe the stuff that they think up to put in these things.
Well, and one of the things that I have seen is that at one point I was working for a firm that did design build, and they were designing their subcontract agreements. And I said, hey guys, this has to, you know, meet the requirements of AIA A201. He said, oh, we don't do that.
Yeah, they don't want to give the sub that much power. I thought that was great to see that in here, that the sub would have, because, you know, incorporating the prime, nobody ever realized it's in there. And they don't realize that they're agreeing to the terms of a completely different contract they've never seen. Which the same goes for a general contractor that signed the contract and doesn't get a copy of the A201. There's a whole bunch of rules in here that they got to comply by that they need to see before they sign up. But
one of the big changes in this last edition is previous editions going back a long time had general provisions for insurance. And in this edition, there is a separate document that covers bonds and insurance. And my suspicion is that a lot of architects and owners are not aware of this separate document that goes into, it can be very helpful on more complex projects in terms of laying out requirements for insurance.
I agree.
And bonds. And it's about 12 or 13 pages long.
Is the edition that goes with it.
And so it's well worth taking a look at. Although going back to the Green Book issued in the late 1970s, Rocky Rothschild in Atlanta said that, who was the first double fellow, said that architects didn't have any business messing around with insurance, much less contract terms, because they weren't insurance agents and they weren't lawyers.
Well, and that's the thing about when you say you go to the job site, you can maybe talk to the superintendent, because what happens then is if you do more than that, then a sneaky lawyer could come around and say, oh, the architect is the owner's, you know, the owner's agent. So now the owner, you know, is out here telling people what to do. And now the owner should be responsible for any job site injuries or something like that. So they, you know, really crack down on how much you say or don't say. It's really, you know, I think a little overkill on the legal side that you couldn't just, you know, point things out when they were being done wrong.
Well, I mean, when I started in this business in the mid 60s, somebody told me that they could count on one death or serious injury for every 2 stories of construction on a high-rise construction. One of the things is that doesn't happen anymore, and it's because especially the larger contractors and many of the subcontractors are very conscientious about safety and know what the rules are. And OSHA, you know, has helped with all of that as well. The architect does not have any idea. about the details with regard to a lot of those safety issues, in my view.
Yeah.
But what do I know?
No, you
I have a degree in fine arts and architecture, and then I went to seminary. I just had 25 years drafting these documents.
Oh, that sounds awesome, especially with the seminary perspective.
It was Presbyterian, so it was good preparation.
Great negotiation skills.
Mhm. Karalynn, it looks like we have another question that was submitted in the chat. What section can we provide the contractor when they state that the submittals are the final document for construction? Is it something that it's something that they've disputed with the contractor and they inform them that they need to comply with the construction documents?
It's not the submittals, it's the payout.
No, no, wrong. It's
What?
the contract documents. And submittals are not contract documents.
I agree, but the A201 says that there is a presumption that the work is done in accordance with the plan and specification once the architect issues a payment certification.
You still have a year to discover construction defects or
No, I agree.
construction
I agree.
non-conformance
I
after
agree, but-
substantial completion.
But I agree, but when you're talking about something that's conforming as opposed to defective, if you finish the project and something is not conforming, but not defective, and it was approved on a pay-up, there's pretty good evidence that they wouldn't have to go back and fix it as long as it wasn't defective. You see what I'm saying? Obviously, it's defective, you have to go back and fix it. But what you're saying, the difference between conforming work and defective work is different, and I agree. But if non-conforming work is approved via
One of the reasons this really makes a difference is because if there's a roof leak and the contractor built it according to the details, then the architect has to pay for it. Okay. If the contractor went and improved the details and did something different and it leaks, then the contractor has to pay for it.
well, then I would say it's defective. It's not only non-conforming, it's non-conforming.
Well, either way,
Yeah, I
it's
agree.
defective.
Or,
Okay.
you know,
And that's the whole issue with, that language.
and yeah. So anyways, but that is the one that I'm talking about is in Article 9 that I brought up in the payout. Let's see here. I don't know if I put in what section. Hang on, let me go there real quick.
Karalynn, hi, this is Linda Camacho with Kirksey. I'm the one that brought this up because during construction, we'd go out to the site and like Peter said, I believe, we observe and inform the GC if there's something that we see it's not in compliance with the construction documents. And they tell me that they're building it per the submittals and not the documents. And that's the dispute I have with them.
Yeah, I agree. I don't think that's correct.
Right.
You build per plans.
Right. And so I just wanted to see where in the contract I could tell them, like, this is where it states clearly, even though I keep telling them, it would be easier. But
The language defining submittals is very interesting because it says that submittals, and it lists 3 items that the architect is obligated to take action on. And it says that these submittals are for the contractor to indicate how he intends to comply with the contract requirements. Okay, and that's a very interesting statement. Okay, they're not for the contractor to go off and redesign the building. Okay, and I know that this, for a lot of contractors who've been around for a long time, dealing with some architects who aren't necessarily ready for prime time, that's very frustrating. However, okay, there's a reason for submittals, and it's not to change the contract documents. Okay, now what you have to look out for is if the construction contract has been drafted so that it says that the submittals are approved submittals are contract documents, and there is there are a form of general conditions out there that indicates that, and it's just wrong. Because what happens is you're changing the contract without the agreement of the owner and the contractor.
And I think, on the A201, you'd really have to get into what is in the actual contract documents to nail that, to look for the language that you're looking for, right? They can't move forward with the work until you architects approve the submittals. Hang on. Okay. Contractor shall not be relieved of any responsibility for errors or omissions in shop drawings, product data samples, or similar submittals by architect's approval thereof. That is 3.12.8, the very last sentence. It says, yes, you'll approve it, but if they miss something or don't do it the right way, they still have to do it in accordance with the underlying documents.
Okay, look at 3.12.4. Shop drawings, product data, samples, and similar submittals are not contract documents. Their purpose is to demonstrate how the contractor proposes to conform to the information given and the design concept expressed in the contract documents for those proportions and blah, blah, blah. Okay. Now then, if this has been changed.
In the general contract.
Yeah, but in the contract between the owner and the contractor, there's not much you can do about it. But that's the standard language. And if I remember correctly, that language goes back 30 or 40 years.
Yeah. And I think that last sentence of the 3.12.8 just sums it up, that even regardless if it's approved or not by the architect, the underlying duty is still to comply with the original plans and specs.
Unless you have a change order.
I agree. I agree.
I think, Carolyn, another question came through the chat from Robert. If I understand the change via markups to submittals issue, what is supposed to change? What is supposed to happen is an official change to the contract documents needs to be issued. The submittal markups do not constitute a change to the CDs. Is that correct?
Correct. And so basically, if there's something you're submitting as a change, you need to submit it. You can do it in the submittals, but for it to be effective, for you to get an increase in price, you need to do it as a change order as well. You say, I see this coming. It's in my submittals. Here's how it needs to change. And here's the increase in price. And here's why. And then the conversation can be had with the architect and the owner as to yes, no, why, and how much. But just putting it in the submittals and then doing the work and then thinking that you'll be entitled to extra, it won't work that way, because it clearly states in the contract documents, if you want to increase or decrease the contract price, it's got to be done by one of the change order provisions that are in here. And it would be the same in the main contract document.
Okay, thank you.
Mm-hmm.
Do we have any other questions for Karalynn? Welcome to unmute yourself if you'd like to ask her directly.
And I think with that process that we just went through is, the submittal would bring up any potential changes that would cause an increase in price. So that would give you a heads up before you did the actual work and then submit a request for a change order.
All right, Scott. Well, if we don't have any other questions, do you want to?
Excuse me, I do have one other question.
Okay.
I'm sorry.
No, go ahead.
It's okay.
Maybe this is a 3 margarita conversation. My wife is a spec writer too.
It's Monday.
Yeah.
Yes.
Today's National Margarita Day.
Oh yes.
One of my favorites is the contractor comes back and says, I didn't price it that way, when it's clearly indicated on the drawings or in the specifications. And the contractor, for whatever reason, has just decided to ignore that. And you know that a big fight's coming, but you'd rather not. And I don't know what to do. I advise my client, they don't allow me to participate in meetings with contractors because of this.
Well, and I think a lot of that too is, this bid versus the specs and the scope, and realizing I've seen so many issues that everybody thinks they're hard to do their bid. They're not. They're hard to do what's in their scope. And so, but if it's in the scope, attached to the scope subcontract, clearly there's no, I mean, the GC's got to do it. I mean, the contractor's got to do it. And
The contractors send out to subs to get prices without giving them drawings or specifications.
and here and therein lies the problem. Again, the sub, submits a bid. The sub thinks they're hired for a bid. So the contractor uses that number, which is messed up. But now not only the contractor has to do it for that price, but the sub has to do it for that price as well. But obviously the sub, it's way easier for him to walk the job as opposed to the general. So, I mean, as a contractor, if you get several bids for the same area and one guy's substantially cheaper, realize what you're walking into, right?
And the issue with that is the guy goes, if I don't take this low bid, somebody else will, and they'll get the project.
Yeah, but where does that end up at the end of the day? If you get,
I understand, but I've had this conversation with a very experienced estimator,
Yeah.
and it's a problem. But this happens even on like CM at risk jobs and negotiated jobs, not just hard bid jobs.
well, but I think that's the whole thing is education. And it's not only at the contractor level, it's at the subcontractor level. And realizing that if you haven't had dealings with the sub before, they might not be as, up to par on everything. And, taking the low bid is not always the easiest way, because especially as the general, man, you can't just walk away. Everybody thinks that there's, okay, I don't have enough money to finish the job, I'm just going to walk away. That's not how it works.
Yep.
You walk away, that's fine. You don't get paid for the work that you did. Now the owner's got to finish, and he normally can't finish for the same contract price. And you now owe the owner for what the difference was. So it's not just you don't get paid for the work you did. You're on the hook for the extra expense, how many ever hundreds of thousands of dollars that is. And where that becomes even more excruciating is if you have a bond on the job, because you really can't walk away, because an owner or the GC will file on either the GC's or the subs bond. So it's not that easy. You got to take some time and realize what you're agreeing to, because as an owner, if the contractor says I didn't bid it that way, well, it doesn't really matter because you signed it that way. And so now you're going to have to do the work, or the ramifications are, the owner can terminate them and still come after them for the difference in the job if they feel that it's worth it.
Well, and I, my response to this is, okay, so you weren't bidding upon on plans and specifications, even though you signed a document that said you were going to. Okay, so is this fraud?
You'd have to prove intent to prove fraud, which I think is an easy case. More likely it was an accident or mistake. No, that's not to say if you got that way and you got down to it, you couldn't sue them for it and prove it, or they don't answer. Where fraud is helpful in a dispute is that fraud is not dischargeable in bankruptcy.
It's not what? I'm sorry.
Dischargeable in bankruptcy. So if you get a judgment against someone or a company that includes fraud, they can't get rid of that in bankruptcy. As where a money judgment, if it's just money, it can be discharged. So
now there's another concept called unjust enrichment that I don't hear referred to very often, but if the contractor leaves out something and has been acting in good faith, the owner may not be able just to demand that he do the work for the original price, if indeed the work that he omitted is worth a lot more.
I disagree. I mean, that's that you could use that if there wasn't a written contract.
Okay.
That's an equitable argument that, man, one world in contracts, good, better, and different, what you sign will be used against you. And there are no set of regulated laws that say you can do this or you can't do that. There are very few things like that the state or the laws have stepped in and said, no, you can't do that. So most things will be enforced, and you can plead that. But if you have a document that you signed agreeing to it, you're just going to have to live with what you signed.
God, I love this stuff.
Well, I wrote a whole book on the contract or subcontract called "Quit Getting Screwed," because so many subcontracts and contract documents out there that are not AIA are horrible. They're so horrible, people don't read them and they just sign them. And I've seen so many people go out of business because they don't know what's in there.
I've got a project right now. I do specs in Hawaii
Mhm.
because I actually used to work out there. And I've got a project now where the owner has hired a project manager who intends to generate his own construction contract and bidding documents. And I warned the architect that this is a real rat's nest and there's nothing we can do about it. And I said, we'll develop our Division 1 and our specifications based on the assumption that we're using AIA documents, because I'm not going to go through and fix all this crap.
Well, I mean, you can't even imagine what's in there.
Yeah.
One way or the
No,
other.
I can imagine.
Whatever side is drafting it, if it's not something that's already pre-negotiated, it's going to be horrible for the other side.
Yeah. Well, and it's a big company. Okay. But even so, in my experience.
Well, the big company has in-house lawyers that are going to write it for their benefit.
No, I just, the last several years, I've seen some real problems.
Yeah, I agree. I agree. They've gotten worse and all the, I mean, like, I remember the first time I read a subcontract, it's like, or a contract that wasn't an AIA, I was like, who in their right mind would sign this?
Yeah.
So, having some semblance of normal or, that what people can agree to and understand what they're agreeing to. The whole thing is about being clear about what's expected. And that way people know. And less disputes and less lawyers and less paying lawyers, because nobody makes money there except the lawyers. Your money is way better spent developing your business and doing other things as opposed to litigation. But
Karalynn, thank you very much for spending your time with us. I would love to get together for lunch sometime and talk further.
Yeah. Why don't they put National Margarita Day on a Friday? Crying out loud.
Yeah.
On Monday. But thanks, guys. Yeah, if you have any questions, you can email me. I know that Lee's going to make sure you get the handout, which has got kind of everything in depth that I said. I've really tried to pull out the main parts and break it down in plain English. But if you have any other questions, you can email me.
Perfect, thank you. And I just sent, it's called Quit Getting Screwed is the book title, Karalynn's book that was just released this year. And we'll be sending a follow-up link. You can purchase it on Amazon and check it out. Thank you all so much. We really appreciate it. And Scott, did you want to close us out?
Thank everyone for joining the presentation. I want to thank Lee and Karalynn for their efforts and everything they've done to make this successful today. Quick reminder, if you need a handout, I have the email. I can send it to you if you just send me your email address. And then we'll have a recording. I'll send it to Lee and she'll get that taken care of. And then lastly, next month's meeting has been confirmed. It'll be on March 22nd at 5 p.m. So we'll send out the Zoom information here shortly. All right, everyone have a great day and week, and I'll see you guys next month. Take care.